Thank you for that. One of the most confusing things that people call me and ask me about is how do I take title to the property? I mean, everybody understands that fee simple means that you're buying the property and the building, but can you explain the differences of deeds?
Sure. So when you talk about deeds and vesting of title, at the limited level or at the base level, it's there's three options. If you're taking title on an individual basis, Mr. and Mrs. Smith are taking title to a property. There's three levels. You can either take as tenants in common, joint tenants with rights of survivorship, or tenants by the entireties. When it's husband and wife, you would want to, I don't see a reason not to, take title other than as tenants by the entireties. And the way we do that in Florida is we vest the title on the deed at Mr. and Mrs. Smith as husband and wife. That language, husband and wife, creates a tenancy by the entireties. And with that come a couple of things. Number one, survivorship rights. If one of the spouses was to pass away, the interest of the deceased party goes to the surviving spouse as a matter of law at the time of death. Nothing needs to be probated. You file a copy of the death certificate in the clerk records, and you're done. The surviving spouse now owns title 100% in his or her name. The other thing that comes with tenants by the entirety's ownership is some creditor protection. So the law treats the husband and wife as almost like one unit, like its own entity. So when you're talking about creditor claims, the individual creditors that may attach to either the husband or the wife on an individual basis do not attach to assets that are titled tenants by the entirety's husband and wife. Joint creditors potentially would have a claim, but it would have to be against both the husband and wife. So if the husband has a judgment against him for $5,000 for his credit card bill, that would not attach to assets that are titled as husband and wife. So there's a couple of benefits there when you're talking about marital couples. And that would obviously be always the recommended way to vest title for them. Joint tenants with rights to survivorship is the situation where two folks are taking title together, but they want the same survivorship rights that come with a tenants by the entirety situation, husband and wife, but they may not be married. Fiancés, boyfriend and girlfriend, family, friends, business partners. Anyone who is taking title together where they want that survivorship right included. If one of them was to pass away, God forbid, the deceased party's interest would go to the survivor at a probate at the moment of death. Same as with husband and wife. Tenants in common is the lower level, and that's where, let's say, two folks are taking title together 50-50, but there are no survivorship rights. So again, God forbid one of them was to pass away, that 50% interest would not automatically go to the other party. That 50% interest would then descend pursuant to that person's will. Hopefully they have a will. Or if they don't and they're intestate, then that would be pursuant to the Florida intestacy statutes. That interest would need to be probated because it doesn't have that automatic survivorship rights. But that interest would then descend to the heirs and devisees of that deceased person, and vice versa on the other side. So that's, at its most basic level, kind of the distinction. But of course, in addition to those types of titling, there's all kinds of other top options. You can do business entities, LLCs, corporations, etc. Trusts, and there's a variety of different trusts, revocable, irrevocable, estate planning trusts, Florida land trusts. There's a wealth of options when it comes to taking title.
So if I were going to take title to a property and I decided that I'm going to put this in a trust and I don't have a trust, how long would it take you to form a trust? Could that be done during, say, the 30 or 45 day period that you're doing a transaction?
Yes. So when you're talking about trusts, you're talking about more of the estate planning type attorneys that are involved in drafting wills and trusts. From a personal standpoint, I don't prepare wills and trusts and do that. I have a department at my firm that have attorneys that do that. That is their sole area of practice. But the situation you just spoke of comes up often, whether it's folks that are already here or out of state. The out-of-state situation arises a lot where folks are relocating here. They may be coming here from New York, and they've been residents of New York for years, and so they have all this stuff done. They have wills, they have trusts that have been created in New York, but now they're moving here, and they're going to be here full-time, and they're going to establish residency here. During closings, we often get asked about that situation. Yeah, is my trust in New York, sufficient? And it may be, it may not be. Florida has very specific homestead laws, and you have to be very cautious when you're making Florida your state of residence and Florida property your homestead, that anything in that trust doesn't violate the Florida homestead laws. So my recommendation in that situation is always to have whatever has been previously prepared, reviewed by our estate planning department, and they will give the guidance, whether it's amending and restating, i.e. starting over with a Florida trust, Florida will, or perhaps just amending what previously exists, codicils and different things like that. If they don't have anything and they're starting from scratch and they want to establish a trust here to take title, we can do that as well. The timing on it is whatever the client need is, but it also involves proactive cooperation by the client. If a client is in the process of getting a loan and doing due diligence on the property, they got a lot on their plate. So they're focusing on getting inspections done, focusing on getting all the information they need to the lender, tax returns and all of that to get approved for the loan. To put that on their plate sometimes is a lot. So sometimes it's something that we try to do after the closing with the cooperation of the lender, because of course the lender, if they're financed, would have to be involved in that. But certainly, yeah, we've done many transactions where we were able to get the trust established, executed, because there's a formal execution process to do that. And then once it's fully signed, executed, etc., then you can vest title in that trust. So absolutely. But I would involve another attorney from my firm if they decided to hire us to prepare the trust, to get involved and sit down with that client, consult with them, and make sure that they have their estate plan squared away.